This presentation is based on my article, Recapturing the Other, Jewish Laws of War and International Law, which appears in the Journal of Law and Religion, Volume 28, Number 1 of 2012-2013. This talk will look at what international law is and how that history links to Jewish law. But first, let me begin with a question. How would you define Jewish law or international law? We know that various peoples always had to interact, predominantly for trade and in times of conflict, and there were always rules that surrounded these interactions. However, international law as we now know it is a specific expression of these relationships. As Matua has noted, international law claims to be universal, although its creators have unambiguously asserted its European and Christian origins. This quote reveals a few things that we can unpack that will help make it clear why it is that I'm interested in the relationship between international law and Jewish law. First, if international law is claiming to be universal, how does that relate to or conflict with religious law, which also makes universal claims? Second, if international law has European and Christian origins, then was there or is there an influence of Jewish law on these sources? Interestingly, international law scholars have raised these questions, but traditionally from the direction of opposing Jewish law and international law. For example, Kennedy opposes them as state law versus mystical law, and he argues that this relationship existed in early international law. The idea was that as international law universalized, it cast out its Christian and therefore trace Jewish origins in its quest for secular universalism. Of course, the scholarship then also sets up religious law in general, and Jewish law in particular, as the other, the opposite of everything that international law aspires to be. But is this true? As Joseph Weiler noted in his reply to Kennedy, Jewish law can be understood as a, quote, legalistic, rule-bound concept of religion that has charismatic movements, but for the most part is concerned with basic principles, such as moving an egg on Shabbat. So this is a concern that an idealized Jewish law is being put into place, but more interestingly, the question became whether these idealized Jewish laws have always been a part of international law. Returning to international law's Christian origins, for example, the first Spanish scholastics were often ecclesiasts, like Francisco Suarez, who was a Jesuit priest, or Francisco de Vitoria, who was a Dominican professor. And this is not divorced from the process of universalization of international law, which was clearly tied to the encounter between Europe and its other, as it expanded, beginning with the encounters between the Spanish and Portuguese and the so-called New World. For example, Vitoria's famous book is called De Indies. This encounter created clear tensions for international law, forgetting for a moment the actual violence that colonization incurred. How could it claim to be universal when it was clearly seeking to manage relationships with peoples who did not have the same worldview? When, for all the scholars up to this point, and up to the religious Reformation, the answer was definitely in the religious realm, specifically under the aegis of the Catholic theological tradition called natural law. These scholars knew the Old Testament, but they did not engage directly with any Jewish law or literature. While it's outside the scope of this talk to go into this or natural law much further, we can take up our story and take as our starting point the Reformation, which was the definitive break between Catholicism and Protestantism. Mark Janis, for example, begins his survey of religion and the literature of international law only at this historical breaking point. And Shabtai Rosen, the eminent Israeli diplomat and international lawyer, argues that it was only after the Reformation that international law scholars began to use Jewish sources in their work. Of particular note here is Hugo Grotius. Hugo Grotius was the Dutch international law scholar who is often considered the, quote, father of international law. A contested title to be sure, but as important as Grotius is and was to international law, he was in fact part of a chain of development of international law in which other Protestant scholars such as Gentili began to use the Old Testament. As Rosen notes, however, it is not likely that Gentili had access to these sources in the original Hebrew. However, by the time Grotius is writing, it is possible that he may have actually had first-hand knowledge of Jewish sources. The evidence is unclear. Scholars as eminent as Salo Baron, Jacob Meyer, Arthur Lowenstein, and Phyllis Lacks have all dealt with this question, and yet it's not readily resolved. Here is what we do know. Meyer argues that Grotius was likely taught Hebrew by another scholar in Leiden, Franciscus Rafelingus. Grotius was also intimately involved with the terms of Jewish settlement in Holland, and he argues for religious freedom on their behalf. We also know that after 1615, as Rosen notes, Grotius was personally acquainted with the leaders of the Jewish community. Lax also takes a detailed look at Grotius's major work, De Jure Belliac Pashas, and which is known in English as the Laws of War and Peace. And he notes that Grotius uses various biblical commentators such as Ibn Ezra, David Kimchi, Rashi, Gersonides, and Abravanel. Although his knowledge certainly doesn't seem to be internal, in that he doesn't seem to realize who is important and who is not in the hierarchy of biblical commentary. For example, he doesn't take Rashi as primarily important. And it's also important to note that Grotius does not seem to have a good sense of the Midrash. He often also misinterprets the Talmud and confuses the Mishnah and the Talmud. This means to me that Grotius was interested but not likely knowledgeable about internal Jewish sources. And importantly, though, to return to the opening point, Grotius did not see these sources as messianic, but as legalistic and rule-bound. It's also equally clear that he did not have a good sense of what the law actually was. I argue in my article that Grotius was in fact appropriating Jewish law and reinterpreting it for his own ends, perhaps as a counterpoint to the traditional natural law theories. He specifically sees Jewish law as part of the natural law theory, but also as a way of expanding beyond its boundaries. It is, as I've put in the article, the fact that Jewish law's otherness can serve as a mirror for Grotius's own project of making international law universal. So this raises the question, where does Jewish law fit into all of this? Is it part of the process of universalization of international law? It is, both because of its incorporation and the fact that it allows international law to claim pluralism. This partially is what I would suggest is Rosen's reason for tracing the history of Jewish law and international law. If Jewish law is included, then there is some role for Jewish tradition in international law, and international law is not just merely Christian tradition. It's also, though, part of Grotius's self-image and his own project of reshaping international law. So there is a role for Jewish sources in international law, but it's not truly a Jewish tradition within international law. Thanks.